Hello everyone, welcome to Court with Krissy. When you're the only one to not show up for your jury trial, it doesn't look good. But this former pro se now wants his bond back. How do you think that's going to end? I hope you like it. Court with Krissy is now in session.
This morning, Your Honor, Mike Roll on behalf of the people.
Something wrong with this.
Thank you, Your Honor. Richard Trush on behalf of Mr. Hillier, but it sounds like they might be having some technical difficulties in the jail.
Mr. Hillier, are you able to hear the court?
Yeah.
Joshua Jacob Hillier,
Yeah.
welcome. So we're here today on a motion filed by the defense to reinstate bond. The court has had an opportunity to review the motion as well as the people's objection and response. The court exercises discretion today under 2.119E3 to dispense with oral argument. I'm very familiar with the background of this case and I'm ready to rule on the motion with the benefit of the motion response. The motion to reinstate bond is denied. There are many reasons for this decision, most importantly of which is Mr. Hillier, as you know, after protracted litigation and nearly 2 years of nothing happening in this case of substance, meaning I definitely had motion hearings, I had the relief of one attorney, I had the appointment of a new attorney, I had ultimately assigned Mr. Trush as stand-by counsel. Ultimately, I had Mr. Hillier, I'm not hearing from you. I'm making my ruling in the absence of oral argument, which I'm entitled to do. To the extent you make a claim or your attorney made an argument that it's not your fault you failed to appear for jury trial, which you did fail to appear for jury trial, I do not find any good cause for that failure to appear. You were arrested and lodged in a different county's jail because you purportedly violated the law in that county. That does not provide a sound or valid or good reason for you not appearing at your jury trial. What happened instead is
argument with my son.
Mr. Hillier, I'm going to go ahead and mute you because I'm not in need of your input and I'm not allowing it. In any event, as the court was indicating, what did happen is the prosecutor appeared with his witnesses ready for trial. It subpoenaed them for the trial that you demanded and requested. Your attorney appeared ready for trial. I appeared ready for trial. Law enforcement, as necessary for a trial, appeared and were ready for trial. The clerk's office appeared and was ready for trial. And some multiple 30-some jurors appeared and were ready for trial. That trial was thwarted entirely because of your lack of appearance. That's not satisfactory to this court, especially not when in this matter, you have consistently demanded your right to have trial. You have rejected all plea offers at multiple final status conference plea cutoffs. You've had motions heard on merits on this case and denied. And ultimately, this case is in need of trial resolution. For your benefit, I've set trial to be resolved, and it will be resolved on June 30th and July 1st. That's the date of trial, and that's the date we're having it. So even to the extent that the attorney suggested to me, or I allowed you to be heard, which I'm not going to, that there was some plea offer that was anticipated by the people or by the defense, I would not permit it. We have many times been to the plea cutoff date. It has come and it has gone, and we're not going to have that. So the only way that the trial doesn't happen on June 30th and July 1st is if Mr. Trush contacts the court and tells me that you, Mr. Hillier, wish to issue a guilty plea as charged. Because I don't expect that, I'm simply keeping the trial dates on as they were stated. And we're going to have the jury ready, and you'll be ready as well. Mr. Trush, Mr. Roll, I view you as a prevailing party for the reasons I've indicated, but I also want to go through, before I have you prepare an order, a couple more issues, and that is with the background of this case, in order to, again, make sure it's clear why I'm denying any request to reinstate bond and why I'm keeping the trial date on. Again, this matter was bound over to this court on November 15th of 2023. We sit here 5 months away from 2 years on the circuit court docket. Defendant was represented by retained counsel, and at one point, again, that retained counsel changed. He had a different retained attorney who stood in for purposes of a motion hearing. I denied a motion that was filed by the defense, and ultimately then the attorney, Warren Wall, filed a motion to withdraw. That was not opposed by Mr. Hillier, and ultimately the court granted the motion to withdraw. That's when I had Mr. Hillier meet with Mr. Hilo to see if he would qualify for court-appointed counsel. At that time, he was arraigned. He was interviewed. It was that time determined that he did not qualify for court-appointed counsel. But Mr. Hillier also explained to me, and what I thought were no uncertain terms, that he did not want to represent himself. He was being essentially forced into that because he could not afford an attorney and they did not deem him eligible for MIDC assistance. So I appointed standby counsel. I would also note that following the trial's cancellation when Mr. Hillier failed to appear, I also recaptured and we went over with the attorneys my indications and my plan moving forward. And I want to make sure each attorney is fully aware of that. That is, I indicated that subsequent to Mr. Hillier being located, at the time we didn't know where he was, that I was going to order that he re-interview with the MIBC to find out if he qualified for court-appointed counsel, because my indication was going to be that bond would be revoked until the trial would be reset. So, Mr. Trush, do you know if Mr. Hillier has been re-interviewed from MIBC and whether or not he qualifies for court-appointed counsel now?
I can't speak to whether or not he's been re-interviewed, but I do know that I was given a notice of appointment.
Okay, so in any event, you understand you are the attorney appointed to him now, not a standby attorney, correct?
Correct. And I just identify that because at the point he became lodged, I don't know if Mr. Gilo would have re-interviewed him or just made the determination that he's eligible at that point.
Right, and either way, I accept that determination. Mr. Rolla, were you aware of that as well?
I was, thank you.
Then, Mr. Rolla, as the prevailing party, I just need you to prepare an order that says, for the reasons stated on the record, the motion to reinstate bond is denied. Can you do that?
Very good, we'll do so. Thank you, Judge.
From the people's stand- I'll hear from each of you in terms of readiness for trial, Mr. Trush, and I'll also let the attorneys make a formal record if they want in response to the court's decision today. So first, Mr. Rolla, did you wish to make a formal record in response to the court's decision on the motion to deny reinstatement of bond?
No, Your Honor, thank you.
Did you want to make a record on that point, Mr. Trush?
As far as the court's ruling, no, I think the court was clear. Obviously, we don't agree with it, but I think the court's ruling was clear. The one issue I did want to raise, though, the prosecutor attached a list, the list of the jurors to his response to the motion. I just wanted to address that to the court because I'm not sure we want that as part of the court's public record. I mean, the jurors didn't actually hear the case, but still, I mean, that's a list of potential jurors from the public potentially being made part of a public record. I don't know that we want that.
Well, the only reason I would question and ask what authority you would rely upon, Mr. Trush, is I generally understand, and I think you being sensitive to the jurors' information being out there is a good thing. And I suppose what I could ask the clerks to do is just simply redact the names or addresses. But the point that I wanted to make sure was clear is that you would have the opportunity on behalf of Mr. Hillier to examine the requested amounts and challenge them for accuracy if you wanted to, because as you know, when Mr. Hillier failed to appear, I ordered that he was going to pay the costs for those jurors. So if I had the clerk's office redact the names and phone numbers from whatever's filed in the clerk's office, would you still be able to reasonably calculate whether or not you think those are fair amounts that are charged?
Yes.
And is that what you're asking then? It's just to have the clerk's office redact names and addresses?
Yes.
Mr. Rolla, do you have an objection to that given the privacy concerns of the jury?
I do not, Judge, but again, for the reasons the court indicated, in case the defense tried to say these jurors weren't there, we needed the information showing that, in fact, they were there and their locations for mileage had been confirmed.
All right, and then from the clerk's standpoint, is there any difficulty in retrieving whatever's filed with the juror's information in the court file and simply redacting that?
No, it just looks like Mr. Rolla attached a copy of the jury sheet that I provided the court the day of trial, and it just has a juror candidate ID number, which doesn't mean anything to anybody, and just their first name and then their per diem. It doesn't give phone numbers or addresses, it just gives them names, and it's attached to Mr. Rolla's objection, it looks like.
So I see that it has full names though.
Yeah, if you would like me to, I have no problem going through and redacting the
Just
names.
redacting names. Let's do that.
Okay.
So the court will grant that relief. I think that makes sense. Mr. Trush, did you have anything else? Well, starting from the prosecution, Mr. Rolla, are there other issues that the court needs to be aware of in anticipation of trial
No, Judge, thank you.
from the defense?
No, Your Honor, I will make arrangements with Mr. Hillier to get clothing for him prior to the trial. Otherwise, I think we're prepared to proceed.
So I hesitate to do this, Mr. Hillier. I've already made the decision that I'm making, but in the interest of fairness, I'm going to allow you to be heard. But I'm going to give you an opportunity to be heard only to the extent that you remain respectful, calm, and express demeanor that I would expect in a courtroom, because this is a courtroom. So if you maintain those things, I will allow you to be heard because I think it's fair given these circumstances. So I'm just hitting the button asking you to unmute. There's usually a button that jail staff can hit there. Mr. Hillier, if you want to hit that button, then you can be heard. You need to also further understand, Mr. Hillier, that anything that you say on the court record could be used against you. It's in your best interest, therefore, not to talk about the charges or anything in the background of this case. Did you want to be heard?
Yeah, my house is in foreclosure. There's no electric there. I'm sure the freezers are probably thawed out by now. Throw my $500 on my books, I guess. See you at court. $500 I posted for bond. Bail bond is to go, just to say I'm going to come back. I haven't gotten any trouble. I haven't ran from any court cases. I'm not some thug that runs around like your state police. I'm not like that. I'm a father of 4. I got 2 armed trained officers bust into my car and assault me when I'm going to get my son in Marquette. And then I get into it, destroys my family. And then on the morning that I'm coming here for court for jury trial, I have 2 officers tell me I have a warrant that I didn't even know I had. They surprised me with a warrant and arrest me because I got into an argument with my son at a hotel. And I went, and I'm time served. I'm time served on that. I pled guilty to a disorderly person and did my 90 days in jail up here in your jail. And I'm time served. The only thing I'm waiting on is you. I built this case that you have no idea if I'm guilty or not guilty on, and it's at my house. And I have nobody to bring it up to me or my lawyer. Both my fucking parents died the past 3 years.
So the court's done hearing from you when you start to use language like that, Mr. Hillier. You don't have a right to be heard when you're being disrespectful, and I explained that before you started to be heard. The difficulty with defendants who speak is sometimes they say more than they ought to, and that's why I caution you that anything that you say on the open court record can be used against you. What you just told me in no uncertain terms is that you clearly violated the terms and conditions of your bond. But you did it in more than one way. One way was that you didn't appear for your jury trial, as I've already gone over. The second was, well, I told you that you allegedly had violated the law in other places. Now you've told me that you pled guilty to violating the law and served your time. That's an additional violation of bond. It's an additional reason why your bond is canceled and will remain canceled until your trial. And so while the court would generally be sensitive to bond modification arguments in other cases, in this case has gone on for too long. I don't find any reasonable basis to continue bond discussions when we have a firm trial date set. And I'm confident that if you share your information that you have at your house with your attorney, you'll be able to get that information and properly submit it to the jury. This case should have been ready to submit to a jury months ago, but it wasn't. And it wasn't not because anyone else failed to appear, because you failed to appear. So again, the court understands your complaints, but I reject them. I hope you find that trial is appropriately set, and will continue on June 30th and July 1st. The court is at recess on this matter.